We are back on the record on docket number 2024-270-E. I think we have everything straight now, and I appreciate your indulgence. We've heard from the parties as far as who's here, and I think now we will turn over to ORS. Thank you, Ms. Torrey.
Thank you, Mr. Chairman. I very much dislike using my computer up here, but my printer at home ran out of ink, so a guy's got to do what a guy's got to do. Good morning, Mr. Chair, Mr. Vice Chair, and Commissioners. Chad Torrey on behalf of the Office of Regulatory Staff. Commissioners, the issues before you today are not novel. The arguments the Commission will hear today have been presented to the Commission in prior proceedings and as recently as last month during the company's 2023 Integrated Resource Plan. As the Commission is aware, the companies operate a dual state utility system serving customers in South Carolina and North Carolina from resources located in both states. In reciting text from the company's filings in this docket, the Commission will hear me use words such as, quote, traditional allocation, close quote, of costs and benefits of generation resources, and, quote, reasonable expectation, close quote, that the costs and benefits of generation resources will be traditionally allocated. Again, these terms and phrases are ones which the Commission has heard a great deal, especially of late. The allocation of costs associated with solar and battery resources that have been selected in the company's most recent 2023 Request for Proposal, or RFP, all of which are yet to be developed or produce a single electron, has no place in the CPRE docket. Yet, the companies are asking this Commission to make those very type of decisions now in this case. I'd like to turn to the statute that has us here. As part of Act 62, the General Assembly enacted legislation which now appears at South Carolina Code and Section 584120E2. And I'll read it because it's a reasonably short statute. The Commission is authorized to open a generic docket for the purposes of creating programs for the competitive procurement of energy and capacity from renewable energy facilities by an electrical utility within the utility's balancing authority area if the Commission determines such action to be in the public interest. I'll most likely refer to that as the CPRE statute. Now, you may recall the Commission first opened a generic docket and then decided to open separate individualized dockets for the utilities. Now, Duke's first CPRE case was held in docket numbers 2022-239E and 2022-240E. In that case, the companies asked for a Commission determination that, 1, accepts the company's 2022 RFP and results as reasonable and in the public interest for South Carolina. 2, affirms that the target volumes and reasonable balance of utility-owned and controllable PPA resources procured through the 22 RFP are needed to serve South Carolina, such that the companies can execute on delivering these system-wide resources to serve future capacity and energy needs in both jurisdictions with the reasonable expectation that the costs and benefits of both utility-owned and controllable PPA resources procured in the 2022 RFP will be allocated to both jurisdictions. And 3, finally, the company asks you to issue an order that provides clarity that the resources procured through the 2022 RFP are needed to serve South Carolina before significant investments are made. Now, ORS opposed the relief sought by the companies. ORS argued that any determination as to whether the particular solar resources identified in the company's RFP were reasonable or in the public interest for South Carolina should be made in a base rate case or a fuel cost recovery proceeding. ORS further argued the CPRE statute authorized the Commission to approve a process for the companies to procure renewable energy, not determine whether particular renewable energy resources, which had yet to even be developed, should be included in the company's respective rate bases or subject to recovery in a fuel case. Now, ultimately, the parties entered into a settlement agreement in that case, which the Commission approved in order number 2024-141. The settlement agreement proposed a CPRE framework consisting of the following: stakeholder engagement, RFP issues after stakeholder engagement, independent oversight, bid evaluation process, bid refresh and cost control mechanisms, alignment to interconnection process, and grid locational guidance to market participants. That's page 37 of your order. The Commission concluded, quote, "The CPRE framework is a prudent and efficient approach to the procurement of energy and capacity from renewable resources within the company's balancing authority areas and satisfies the requirement of South Carolina Code and Section 584120E2, the CPRE statute." That's at page 38 of your order. The Commission also concluded, quote, "The 2022 RFP demonstrates the companies adequately followed the framework and resulted in a fair, open, transparent, and non-discriminatory procurement. The Commission also finds the 2022 RFP is a reasonable step for the companies to take at this time towards procuring renewable generation. The Commission's findings regarding the 2022 RFP also shall not equate to the approval of and shall not be used as dispositive or presumptive evidence of matters including but not limited to the following: the reasonableness or prudence of any specific project activities related to the 2022 RFP, future recoverability of specific items of costs related to the 2022 RFP, or pre-approval of any rate-making treatment related to the 2022 RFP. In addition, and notwithstanding the findings herein, this is still your order, the 2022 RFP, including but not limited to the associated costs and project activities, is conditioned on and subject to a full review by the Commission, ORS, and other interested parties for reasonableness and prudency during future appropriate cost recovery proceedings. Further, the Commission retains full discretion to determine, and ORS and other interested parties retain full discretion to make recommendations concerning rate-making treatment of the 2022 RFP and future appropriate cost recovery proceedings. The Commission also finds it's appropriate for the companies to retain flexibility and responsibility to prudently, effectively effectuate, complete, or abandon the 2022 RFP and any of the projects set forth therein. Finally, that's at page 39 and 40 of your order. So I know that was a little lengthy recitation there, but I thought that necessary to sort of set the stage.
Mr. Torrey, I don't mean to interrupt. Well, I do mean to interrupt. I'm
Yes.
sorry to interrupt.
Yes,
Let's put it
Commissioner.
that way. The language you just read from the order, that was also language in the settlement agreement, was it not?
That is correct. Yes,
Thank you.
Yes, Commissioner. So having established a CPRE program for the companies, the Commission's duty under the CPR statute was complete. Nothing in the Commission's order contemplates a subsequent CPRE filing by the companies. Nonetheless, the companies thereafter filed a letter with the Commission on April 23rd of this year. Therein, the companies requested, quote, that the Commission establish a new docket for the purpose of receiving information on and considering for approval the company's 2023 solar and solar paired with storage resource procurement program, their 2023 RFP. The companies further state their intention, quote, to file an application for commission acceptance and approval of the 2023 solar procurement program in late 2024, as the companies believe continued oversight, guidance, and decision-making from the Commission are necessary as the companies seek to procure new generation resources. The companies then filed an application for approval of their 2023 competitive procurement, and that's docket 2024-144E, one of the dockets that we're here discussing today. Therein, the companies requested the Commission, quote, approve the 2023 CPRE program and find that it is in the public interest and will provide benefits to South Carolina customers. That's application page 3. The companies further state, quote, the 2023 CPRE program utilizes the company's Commission-approved framework to procure new cost-competitive solar and solar plus storage within the company's balancing authority areas in South Carolina and North Carolina. The application page 22. So the Commission approved the CPRE framework for the companies in the first CPRE dockets. The companies confirmed that they utilized that approved framework to develop the 2023 RFP. So at most, the companies should be seeking confirmation from the Commission that they developed the 2023 RFP in accordance with the approved framework. Yet, the companies seek much more. The companies claim, quote, while the 2023 CPR program is distinct from and contains important iterations on the 2022 CPRE program, the findings the companies are seeking from the Commission in this proceeding are substantially the same as the findings the Commission granted with respect to the 2022 CPRE program. That's simply not the case. Rather, the companies are seeking the very type of relief here that they sought in the first CPRE program, but were unsuccessful in securing. Let's look at what the companies are asking you to do in this docket. And we won't go through them all, but just a few. The companies respectfully request that the Commission issue an order approving the 2023 CPRE program and specifically finding that. And let me back up 1 second. The 2023 CPR program is the 2023 RFP. In the first CPRE docket, there was a framework and an RFP. Since we now have the framework, the CPRE is the RFP. So they're seeking a finding that the company's balancing authority area-wide 2023 CPRE program is in the public interest and complies with South Carolina Code AN 584120E2 and is consistent with South Carolina law and regulatory policy. Okay, on its face, maybe not so bad. I don't know, we'll see. Then they ask for you to find that the company's design and implementation of the 2023 CPRE program ensures the companies are able to procure identified needed additional solar and solar paired with storage resources in a cost-effective and non-discriminatory fashion to serve South Carolina customers with traditional allocation of such resources intended for South Carolina needs. This will further the economic operation, reliability, and sustainability of the electric grid within the balancing authorities of the companies. Last one of these, I promise. Let's look at number 7. The companies are asking you to issue an order determining, quote, resources procured through the 2023 CPRE program are needed to serve South Carolina such that the companies are empowered to execute on delivering these system-wide resources to serve future capacity and energy needs in both jurisdictions with the reasonable expectation that the costs and benefits of both utility-owned and controllable PPA resources procured in the 2023 CPRE program will be allocated to both jurisdictions, provided the resulting projects are prudently executed upon. In the alternative, if the Commission does not make such finding, the companies request an alternative finding that the traditional allocation of generation resources sought through the 2023 CPRE program will not apply, and that the Commission agrees that South Carolina retail customers shall not receive the benefits or costs of such resources. Now, despite the rather plain language that we covered there, the companies nonetheless claim that, quote, they are not seeking any cost recovery determination or any other rate-making treatment in this docket. And the companies expressly acknowledge in both their application and witness testimony that costs related to the 2023 CPRE program will be subject to a prudency review in a future proceeding, and that's in their response brief at page 2. Yet, I think it's pretty clear, it's clear to me anyway, for what that's worth, that the companies tell you exactly what they're going to do in number 7. The companies are telling the Commission that they're going to procure the solar and battery resources identified in the 2023 RFP. And if South Carolina ratepayers do not want to pay for those resources, the actual costs of which remain unknown, the Commission must tell the companies now in this CPRE proceeding. Such a demand goes well beyond the parameters of the CPRE statute, frankly places this Commission in a very untenable position. Commissioners, the Commission should grant the ORS motion for declaratory order and nip this vast overreach in the bud. Thank you.
Thank you, Mr. Torrey. Would you stay there just 1 second? I want to give commissioners an option if they want to ask questions now, and certainly there may be questions after all presentations. Do any commissioners have any questions they'd like to ask at this time? Commissioner Williams.
Thank you, Chair Powers. Mr. Torrey, I think I heard you talk about the first process in which the company was denied approval. I hate to make you reiterate any of that, but somehow I did not hear that in what you were laying out in the foundation.
And that's a great point, Commissioner Williams. The first CPRE dockets were resolved via settlement agreement that the Commission approved. The point that I inartfully was trying to make is if you look at what the companies were seeking in the first CPRE program from the Commission, they were seeking the same type of relief there that they're seeking here. That's a great point. There was
You-
not a denial.
There was a settlement agreement.
Yes.
Thank you. I appreciate the clarification.
Thank you, Commissioner Williams. Any further questions at this time? Thank you all. Mr. Welborn, one of you is next. Thank you, Ms. Torrey.
Thank you, Mr. Chair. Good morning, Vice Chair Williams, members of the Commission. Sam Welborn on behalf of Duke Energy Carolinas and Duke Energy Progress. The motion that we're arguing this morning frames the question to the Commission as being whether the Commission is required to approve each CPRE program a utility puts to it for review and evaluation. We, like the Commission, want to make sure that we're on the right side of the law, that we're on the right side of the policymakers as we're thinking about these kinds of statutory construction issues. I've asked to be handed out the statute that Mr. Torrey read earlier. In South Carolina, as y'all are aware, when we try to construe a statute, we use the plain meaning rule. So the plain meaning rule says that where a statute's language is plain and unambiguous and conveys a clear and definite meaning, the rules of statutory interpret.
Mr.
Yes, sir.
Welborn, not to interrupt you, but.
Hand out one. Yes,
Do
sir.
you have copies of these for all commissioners?
I do. Do you not have them? Yes, sir, I do.
Okay, we got them. Thank you.
Good. Thank you. Where the statute's language is plain and unambiguous and conveys a clear and definite meaning, the rules of statutory construction are not needed, and the court has no right to impose another meaning. And that's a Hodges versus Rainey case that I think y'all have probably heard from before. The motion in this case doesn't really try to attempt to construe the statute. There's a lot of shoulds in there, a lot of what should or shouldn't be done, but not objective discussion about what the statute says. So why don't we start there as part of this discussion, and y'all have that handout. So the statute says the Commission is authorized to open a generic docket for the purposes of creating programs, plural, for the competitive procurement of energy and capacity from renewable energy facilities by an electric utility, singular, within the utilities, singular, balancing authority area if the Commission determines such action to be in the public interest. So just as a starting point for this discussion, the General Assembly has set the stage where there are multiple CPRE programs for the utilities that are coming before this Commission. The Commission's regulations, as y'all are frequently reminded of, at 803-823 permit utilities to file applications for, quote, any authorization which the Commission is empowered to grant under its statutory authority. So just as a starting point, we're squarely under the law and the regulations and seeking Commission review of our 2023 CPRE program. The Commission opened a generic docket, as Mr. Torrey mentioned a while back, initiating these filings. Y'all will remember, again, as Mr. Torrey pointed out, that in the last CPRE proceeding, the Commission did two things. One, they approved the framework under which the companies execute their CPRE programs. And number two, the Commission reviewed and evaluated the 2022 CPRE program. As related to the 22 program, the order made specific findings, again, consistent with a settlement agreement and a joint proposed order filed between the companies, ORS, and other parties in that docket, that number one, the companies adequately followed the framework. So it compared the framework that was approved in that proceeding to how the companies executed on the 2022 program. It also found that the 22 program resulted in a, quote, fair, open, transparent, non-discriminatory procurement. So it made an affirmative finding that the execution of that 22 program was fair, open, transparent, and non-discriminatory. The order also found that the 22 program was, quote, a reasonable step for the companies to take at this time towards procuring renewable generation. And again, that was based on the settlement agreement. That was based on a joint proposed order filed with this Commission. We believe that the 2023 CPRE program warrants a similar review to ensure that we follow the framework, to ensure that the 23 program was, quote, fair, open, transparent, and non-discriminatory, and to ensure that the 23 program is a reasonable step for us to take towards procuring renewable generation. You'll have the second handout, and I should be arguing from the other side, so I could put it on the screen for folks at home. I apologize. But there are important differences between the 2022 CPRE program and the 2023 CPRE program that we believe warrant Commission review and evaluation. Those include the resource types that the companies are procuring. So before we had just solar resources, now we have solar and solar paired with storage resources. The procurement volumes, or the amounts that we're procuring, changes to the bid evaluation process, certain cost control mechanisms that we're implementing for the first time in the 23 CPRE program, and then a change to the associated interconnection study process so that these resources will have assurance that they're going to be interconnected in an orderly way. So there are important changes, again, between that 22 program that the Commission had reviewed and opined on and this new 2023 CPRE program. And remember that when you go back to the language in the statute, the General Assembly contemplated the Commission reviewing not only the company's framework, which we've already put before you, but also multiple CPRE programs. So to us, it makes good sense, it makes complete sense that the General Assembly would want the Commission to continue its oversight of its regulated utilities CPRE programs as they change over time. We also believe that it would be inefficient and highly problematic for a party in a future rate case several years down the road to argue that we had executed on these programs, on these procurements, in the wrong way, and therefore the resources or the cost shouldn't be included in the rate case. So, we think it's appropriate under the statute to put those execution of the CPRE programs before you now, so that in future rate cases, we have a much more efficient and streamlined proceeding where we're not rewinding years and looking back at how the companies may or may not have executed a CPRE program. Was it in line with the framework, and all the things that the Commission found as related to the 22 procurement last time around. So that's our view of the law and the facts. Now I have a couple of rebuttal points in response to ORS's motion. First, in response to their allegations that the Commission's oversight of CPRE programs that its regulated utilities put before it would somehow result in premature rate making, we disagree with that. We're not asking for any rate predetermination in this proceeding. If ORS or a party disagrees with any aspect of our CPRE program or any relief that we're seeking in the docket, they can make their positions known in that docket. We don't need to have a generic proceeding with lawyers driving from all over the state to argue about what the Commission is or isn't authorized to do. ORS and other parties in the CPRE docket that the Commission has already established will get a fair shot to weigh in on the request that the request for relief that we're seeking in our application through testimony and other procedurally appropriate avenues. Counsel for ORS said that the issues we're discussing this morning are not novel. That's absolutely right. This was first discussed when the Commission issued an order approving our 22 CPRE program. The second time mentioned by Mr. Torrey was when the Commission issued an order in May, Directive Order 2024-341, over ORS's objection to open up docket number 2024-144E for the purposes of, quote, considering for approval the company's 2023 solar and solar paired with storage resource procurement program. So we're, the water's under the bridge at this point. We're creating a lot of work and churn when these issues have already been resolved by two things. One, the plain language of Act 62 and the prior actions of this Commission. One other quick responsive note is that to us, it's perfectly reasonable that the Commission's review of the company's CPRE programs may look different for different utilities that come before this Commission. For one, Santee Cooper is under a completely different statute, Act 90, with completely different provisions, so we're going to decline to offer an opinion on the statutory provisions that apply to Santee Cooper because they're distinct and different from those that apply to the companies. Duke Energy is subjecting itself as a regulated utility to the Commission's oversight, pursuant to the authority granted to the Commission under Act 62 and its prior exercise of that authority. We're also wary of the Commission's decision in this proceeding establishing a binding norm. If the Commission makes an affirmative declaration that applies to all electric utilities in South Carolina as related to their procurements, it may be more appropriate for that to be done in a rulemaking proceeding under the Administrative Procedures Act. So some caution there we think is appropriate. Instead, we think that what the Commission considers and takes up should be specific to the applicable laws and facts of utilities application put before this Commission. Again, noting that Santee Cooper is under an entirely different statutory regime and may have different facts and circumstances and laws that apply to it. So in conclusion, the statutory language explicitly contemplates the creation of multiple CPRE programs as relevant to a single utility. We submitted a lawful application to the Commission under its regulations. The Commission reviewed our 22 CPRE program and opined on specific elements of it. And our 2023 program has certain specific changes from the 22 program. Again, as shown in your handout, we believe that it warrants a similar review. Thank you.
Thank you, Mr. Welborn. Commissioner Belson.
Thank you. Good morning, Mr. Welborn.
Morning.
If the program before the commission today was just a solar procurement, didn't include storage, and didn't have any of the other changes, I think there's some additions. Maybe the only change would have been procurement volume. Let's say that was the only change. Would Duke have felt the need to seek approval of that CPRE of that program?
First, it's difficult to answer the question because things, as you pointed out, have changed between the two procurements, but the answer is yes. Again, if I go back to Act 62 and the contemplation of a single utility filing multiple CPRE programs for the Commission's review and evaluation, to me, that's multiple programs. I think in any case, irrespective of whether a company or utility feels statutorily compelled to file an application with the Commission, the fact is we did file an application for the Commission's review of our CPRE program. So I think there's a little bit of a nuance there. I don't want to make it sound like utilities are required. That isn't our position. But certainly the Commission is authorized to review an application for review of a CPRE program when the utility files it.
Well, let's look back at the statute and 584120E2 that you provided to us. Why would it have been a generic docket if it wasn't going to encompass the procedure that would apply to other contemplated programs or other iterations in other years? Why would that have been a generic docket?
Yes, ma'am. As I read the statute, the Commission is authorized to open a generic docket if the Commission determines such action to be in the public interest. I think there was a decision point coming out of Act 62 as to whether the Commission believed solar and other renewable energy resources should be procured through the competitive procurement process. That was the question that the Commission addressed in that prior docket. I think it was 2019-365E. The Commission said, yes, let's do it. Let's move forward. And so the companies filed their request for approval of the framework and also of its first CPRE program to fall under that statute.
And if I'm following what you're saying this morning, and I hope I am, even if the Commission approved the framework and had not envisioned a utility coming back for approval of each of its programs, is it your position that a utility could voluntarily come in and ask for approval?
That's exactly my position. I think 103-823 permits applications to be filed for relief and review that the Commission is authorized to issue. And then when you square that against Act 62, it's perfectly reasonable and in my view, squarely within the law for a utility to come before this Commission to seek its review.
If thinking back on Order 2024-141, if the Commission intended that framework to apply to future programs, is it Duke's position that because, and I think I'm asking the same question I asked earlier a different way, that because storage was added to this one, that this program would require specific Commission approval since it was different than the last one, even if the framework for CPRE programs was approved?
Again, I think even if everything was identical, even if the resources didn't change, the quantities didn't change, the resource plan didn't change, right? All of these circumstances that are changing in real time all around us at any given moment, even assuming those hadn't changed, my view of the CPRE statute, our view of the CPRE statute and the Commission's regulations would authorize utility to come before this Commission for an independent review. I think of one additional example. When you consider how a CPRE program is executed, there's stakeholder engagement on the front end ahead of issuing the RFP. Then you conduct the RFP. You send out messages saying, "Hey, send us your bids. Send us your bids." You have an independent evaluator that's looking at the activities that are a part of that execution process. The independent evaluator, after the RFP is completed, pulls together an evaluation report reviewing the specific activities, the fact-specific activities of the utility. Did they do this right? Did they, were the sort of in-house people, were they cordoned off? Were they separated off? Did anybody, breach basically the rules of the framework? Was everything above board? And so that to me is necessarily a very fact-specific exercise that frankly warrants oversight from the regulator.
All right, I appreciate that. Do you have your application?
Yes, ma'am.
handy? And let's look at, I call it the prayer for relief, page 24, paragraph 27 that was referenced by Mr. Torrey. And I believe in Duke's response to the motion, I think this is the original response. There have been several responses and replies, but I think this is the one of September 9th. Duke indicated that it is not seeking a cost recovery determination in this application. Is that a fair
Exactly.
summary? Can you explain to me why paragraph 7 of the application is in there?
I'd be happy to. So this is similar relief to what the company's requested as related to the 2022 CPRE program. So I can provide the site to where exactly we requested it previously. But and as you know, and as Mr. Torrey pointed out, we achieved settlement in that docket, and this was not something that was addressed in the settlement or in the commission's final order, as relevant to the joint proposed order that was filed. And so it's true that sometimes, you set forth your prayer for relief, and when you settle the docket, you don't get everything you want. When you look at the language of that paragraph 7, it does not ask for a rate determination. It asks for an expectation, a reasonable expectation that the costs and benefits are going to be allocated, in a traditional way. To me, if the commission decided in that docket, so again, this is a generic proceeding involving other utilities to discuss, I think, more generally the issue of whether the commission is authorized or required to take up utilities' CPRE programs. But in the docket, or us to quibble with that language, or to say that, gosh, I really don't think the commission can go quite that far, but what if it approved the CPRE program and, approved the resources? And I guess what I'm trying to say is this is similar relief to what we requested last time. It does not request a rate determination. There's no rate making that's going to come out of this proceeding. There's, our rate and accounting people are not going to have to crunch any numbers after this. But we do think it's fair for the commission to weigh in on whether the CPRE program was executed fairly, whether the resources in the CPRE program square against the resource planning numbers, for example, for specific resources, and ultimately, if the commission says, hey, we really don't think you guys should have procured all that solar, or we really don't think those solar paired with storage resources are what the state needs as relevant to maybe the resource planning exercise, it would be very efficient for us to know that now.
I think part of my concern with some of the language in that is if a utility comes in and asks for relief in some regard, or approval of a program, and the commission grants that, I can't control what the company's expectation is for the future.
Sure.
But I recognize that things that the utility does are going to show up in a rate case. Mm-hmm. And I mean, I hope that the utility understands that they will be afforded all consideration and proper consideration in rate-making proceeding.
Yes, ma'am.
But I can't guarantee anything.
We're not asking for a guarantee whatsoever.
And I can't control the expectation the utility may have.
That's fair. What I will say is that in the last order, there was good language, and I think Mr. Torrey quoted this morning, that parties in the commission will have, there's no sort of right infringement. In a future rate proceeding, all bets are off. You guys will be able to do your regulatory duties and reviewing the rate case and making the right decision. So, we execute on the procurement. We're seeking commission review of the procurement program. But the companies retain managerial discretion, as to whether to pursue certain resources and that kind of thing. So we're not at all asking for any guarantee, no rate making opinions from this commission. Short of, it would be great to get a thumbs up or thumbs down if y'all think if something's really sort of off track
On the program.
on the program. Yes,
Okay.
ma'am.
All right.
Exactly.
Thank you, Mr. Wilson.
Thank you.
Thank you, Mr. Chairman.
Thank you, Commissioner Belson. Commissioner Caston.
Thank you. Good morning, Mr. Webber.
Morning.
In a letter, September 9th, I guess, Mr. Nathan N. Haber sent letter following response in opposition to ORS's motion. And when I was looking through all this stuff. And it's been read a few times, the statute on CPRE, the one sentence statute. On item 2 on page 2 of this letter, ORS's claim is such and such, and the response from the company is such and such. This is page 2 of 16 in that letter. In the second item where it says, ORS's claim is the commission provided the company's necessary guidance and approval for it to administer future procurements. And the company's response is false, and it says, while the commission-approved framework provides a general guide for the company's administration CPRE programs, the specific relief requested by the company will, and then go on to say, allow the commission to evaluate 2023 RP, CPRE, ensuring that it complies with the commission-approved framework and that the 2023 CPRE program resulted in fair, open, transparent, and non-discriminatory procurement. And, there's the item 2, the commission find just as it did that the 2023 CPRE is a reasonable step the company take place. What I'm really trying to understand also is that the framework seems to be, that's what it was. It was a framework for fair, open, transparent, and non-discriminatory process. And unless the commission were to change the framework is still the framework. So why would it be difficult? I suspect if the folks that were participating in it didn't think it was fair, someone would let us know or let ORS know. So what I'm trying to understand is what more is there to do beyond what was done? The framework was approved.
Yes, sir. The framework provides the skeleton, right, by which the meat of the CPRE program is held up. The program is premised on the framework. So if we change something in the framework and we run a CPRE program that's not based on the commission approved framework, certainly that would be problematic. But even if we meet the sort of broad stroke requirements of the framework, the very high level, basic, fundamental requirements of the framework, it's still true that a utility could, around the edges, inappropriately administer a CPRE program. Certainly, I'm not asserting that the companies did that, but we believe that it's entirely appropriate for the regulator to trust but verify, right? So we filed an application asserting that we followed the framework, we did what we were supposed to do, but as a regulated utility, I feel like it's the regulator's role to sort of look over our shoulder and ensure that we're meeting the requirements of this commission.
Okay, I want to make sure I understand what I've heard program mentioned. You have the framework and then you say the program. What is the company's definition of the program? Is it, well, I'll let you tell me.
Sure, yes, sir. So it's a little more involved than just the procurement itself. So you post the procurement to the website. Interested bidders review that RFP, and they submit their bids. The more global view of the CPRE program, there's a series of stakeholder engagement meetings that happen on the front end to get feedback from interested parties on the design of the procurement. Again, within the bounds of the framework, but there are nuances, and you have the handout there that shows changes or improvements, I would say, between the 2022 CPRE program and the 23 program. So you start with stakeholder engagement. You post the RFP so that interested bidders can, start to pull their bids together. And I'm sure Mr. Burns or Mr. Witt can speak more intelligently about what that process looks like. When you're done with that procurement process, the bid window closes, right? You're done with the procurement. We've got an independent evaluator that comes in, reviews, make sure, at least in their view, everything was in accordance with the RFP that was issued. They pull together an independent evaluator's report. So all this is done after the procurement concludes. And so when you look at the CPRE program in total, it's not just that document that says, here's what we're looking for. It's the whole part and parcel. How was it executed? What was the legwork going into pulling the RFP together? Did they do it right, on the back end according to the independent evaluator, which again is a third-party consultant. So there's more to it, I guess, is what I'm trying to say than just the RFP itself.
And all of that is part of the framework, right? The stakeholder process, the RFPs, and
all of it's under the framework. If you think about the state constitution, for example, it provides broad parameters of expectations for state citizens, right? But then you have all these laws that come under the Constitution. And then even under the laws, you have all these regulations that come under those laws, right? So you start with the skeleton framework of the Constitution, and then you have all these laws and regulations that sort of put meat on what the drafters intended.
And just for point of clarification, I'm pretty sure it's a typo at the bottom of that page 3 where you're referencing 5841 2E2. That's 20, correct?
Yes, sir.
Okay.
That's correct. Good catch, sir.
That's all I have right now. Thank you.
Thank you, Commissioner
Mr.
Caston.
Chairman, can I follow back up on something?
Commissioner Belser.
Mr. Welborn, this RFP's not been put out publicly yet, has it?
This one has, yes, ma'am.
Okay, so I started thinking about the concern of delay and regulatory putting the brakes on things that the utilities need to be able to do. I don't want, however we come out of here, of this argument, I don't want the utilities to be delayed in implementing something they think they need because they may have to come to the commission and get approval, and we don't know what's going, we never know what's happening on the calendar, and we can't get to something as quick as we need to.
I appreciate that concern. In the 2022 CPRE program that the commission had reviewed, we ended up holding that proceeding in abeyance because it was clear that at least some parties were interested in reviewing the results of the RFP and the independent evaluators report. The record felt incomplete, I think, to the participants without it getting to a stopping point and having that IE's report. And so rather than file it too early this time around, we waited until the appropriate time when we thought that all the information that the commission would be interested in and other parties would be interested in were ready to be filed. So we did the pace a little differently this time to avoid that exact issue.
Okay, thank you.
Thank you, Commissioner Belser. Any other commissioner questions? Mr. Welborn, just a couple of things I was interested in. You mentioned us as the policymakers in South Carolina. It's fair to say we are not the policymakers.
100%, yes, sir. Members of the General Assembly.
Okay. We certainly have a lot of discretion, but we're different than some states as far as what we can and can't do.
Yes, sir.
You mentioned rulemaking. Could you explain? You barely mentioned it, or
Yes,
I
sir.
didn't catch exactly where were you going with that, or what do you have in mind when you say there may be some rulemaking necessary? Can you explain that?
Yes, sir. And I barely mentioned it because I'm not in a position to admonish this commission. That's not my role. But I think it's a point of caution that the companies have, and it's discussed in a little more detail in the letter that we filed on Monday of this week, in case there's more detail there. But headline is we were concerned, based on the request as presented in the motion, that the commission coming out of this generic proceeding would issue an order, for example, requiring every utility to file their CPR, each annual RFPs with the commission. That's not our position. We don't think that the commission needs to dictate utilities filing their RFPs with this commission. We think there's some reasonable latitude there. And also that when the commission issues a decision that establishes a binding norm, there's precedent in this state that says that binding norm really should have been part of a promulgated rulemaking process under the APA. So it's just a sort of some wariness about what comes out of this docket, and ensuring that we're not establishing a binding norm that, for example, puts utilities under some obligation that might have been more appropriate as part of an APA promulgated rulemaking proceeding.
And from that, then the extra filings would certainly be more delay.
Yes, sir. Mm-hmm.
And,
More delay, exactly, because those processes take time.
All right, so thank you very much. That's all I have.
Thank you, sir.
Any further, Commissioner Williams?
Thank you, Chair Powers. Good morning, Mr. Welborn.
Morning.
I want to go back to paragraph number 7 in the application. And I guess what I want to understand is the thinking behind the alternatives that you give us in that paragraph, and the relationship, because you are a two-state jurisdiction, the references that are there to the allocation involved. You may have covered it, but if you could kind of more succinctly respond to why those elements are in the application.
And this may be discussed in more detail in our verified pre-filed testimony, which we filed with the commission. But what that is intending to communicate is that, and it's similar to something one of our witnesses said in a prior hearing, which is that rather than the companies expend hundreds of millions of dollars or whatever the number is, and then come in later and have a party argue that this is way off base, you guys did the CPRE program wrong, you didn't do X, Y, or Z, or we don't want those resources, we would be in a much better position knowing whether those factors are at play now, rather than waiting until those investments are made. Does that make sense?
Mm-hmm.
Okay.
I think, and it may be, as you said in the testimony, but I haven't gotten there yet.
Mm-hmm.
But I think it appears to me it's a matter of communication and what the words mean, and that is what this circumstance boils down to. And I guess I put that out there in case you want to add more to your thoughts on that.
Yeah, I mean, generally the watchword here is transparency. We don't want to be sort of sneakily doing things right and then coming in for a rate case and, drop a surprise in your lap. We would much rather have a healthy, constructive relationship with our regulator to ensure y'all know what we're doing. And if it's not something you want us to do, let us know, while at the same time retaining our managerial discretion and our own responsibility and duty to prudently execute on our statutory obligations. So there's a tension there, right? But absolutely transparency, ensuring that you guys are aware of what we're up to, and that we're all on the same page.
But in this circumstance, you're not asking for any approval of prudency of the cost associated with the program.
Absolutely not.
Thank you very much.
Thank you.
Commissioner Cass.
That kind of follow up on that. Hearing all this and reading what I've read, talking about the program, the nuances. I want to make sure, at least I want to make sure I understand, that this isn't a request, or is this a request for a pre-approval of any source generation? Because it's one thing about a program and nuances or a framework. It's another thing to say, we kind of want, we want to make sure we're on the same page here, and, we're going to be using this source, and this source, and we want to be kumbaya when we leave. That still kind of seems like a pre-approval, and it's the utility's responsibility to choose what the generation sources you think is appropriate. Is that a fair statement?
I think it's generally fair, though. I mean, you're well aware that this commission reviews the utilities resource planning activities. It's certainly the utility's responsibility to prudently execute on resources. We've put forth, again, I don't want to get into the resource planning, sort of what that proceeding is about, but if you repeat your question, I can try to answer it more succinctly. I don't want you to be annoyed with me, but I didn't completely agree, I think was the...
I'm not trying to trick you,
Yeah.
Well, I promise you. The role of the commission, can be debated by many. I believe I understand what that is. But you, or the company, as a representative of the company, do you believe it's our role to tell the utility what generation sources to pick, when to use them, where to put them?
No, sir. I believe that the resource planning proceeding is the appropriate proceeding in which to work out those issues. I'll also give you and this commission assurance that when it's time for the companies to execute on a resource, we're going to come before you in a Siting Act proceeding. There are other sort of various regulatory interactions, that a utility has with this commission, and this is not the kumbaya. We're not looking for a kumbaya at the end of this, as much as that might be nice, right? There will be other opportunities for us to interact and engage on various resources that we're executing on.
Thank you.
Thank you,
No
sir.
question.
Thank you, Commissioner Casson. Any further commissioner questions? Commissioner Williams.
Mr. Welborn, so picking up there, let's say it's time for the next rate case or the next siting application or the next IRP. How will a decision regarding your application be relevant in those three circumstances?
It's a data point, right? And so when we're coming in for a rate case, and let's say there's a resource coming out of this CPRE program that's in that rate case, the commission will have assurance that that resource was procured in an above board way. So we have the framework, CPRE program. We executed the framework in an appropriate way that reflects this commission's orders. But then the resource has to be built, right? It has to be sited. There are other activities, but the commission at least will have already addressed the procurement of that resource. So one of the concerns that I flagged in my argument was, let's, if we don't do any of this, if we don't do any of this exercise in terms of reviewing the procurements, when we're in a future rate case 3 years from now or 2 years from now, whenever it is, and you guys have a resource in front of you that, somebody's pounding the desk about, are we going to have to go back at that point and review that series of CPRE programs and say, all right, it was this program and did they do it right? And, oh gosh, they should have done this differently. And it's just, it'll make for a much more streamlined and efficient proceeding if in a future rate case, the commission could say, we looked at that procurement is good. Here's the order that says it is.
It feels to me like the devil's in the details and what would go in that order in terms of the limitations of what it means.
And again, I'll point back to the 2022 CPRE program order. There was great language in there about full reservation of prudency review and execution risk. And, there's good language in there. I don't have it in front of me. I could pull it up, but we're not trying to, pull a cloak over anybody's eyes here. We're trying to be transparent, put the CPRE program in front of this commission in accordance with Act 62.
Thank you. Are there any lessons learned or standards from what North Carolina requires that are relevant for us to understand, or that caused you to write number 7 in your application the way you did?
You might need a fact witness to weigh in on that. Is there anything that the North Carolina
Commission's statutes require that cause you to do something unique in South Carolina in this application?
No, ma'am. So as you're aware, we're a dual state utility. We have a large footprint. Many customers in North Carolina are served by South Carolina resources and vice versa. There's nothing, no, absolutely not. I mean, so, we filed for approval. It's a single balancing system wide procurement. And if you look at the statute, it says that, programs can be created by an electrical utility within the utilities balancing authority area. So, there's an allowance there for dual state utilities to file these kinds of things. And so short answer is no, but there's a lot of good reasons why we did what we did.
Thank you. I appreciate it. No further questions.
Thank you, Commissioner Williams. Any other commissioner questions? Thank you, Mr. Welborn.
Thank you, sir.
Good job. Dominion Energy South Carolina Incorporated. Mr. Burgess. Mr. Burgess, do you have any kind of guess as to how long your presentation is?
I do have a guess. It runs about 12 or 13 minutes.
Okay.
And subject to obviously any questions that y'all may have, and you can feel free to interrupt me along the way.
We'll do that before we take a break.
Okay. All right. Very good.
Thank you.
Good morning, Mr. Chairman and members of the commission. I'm Chad Burgess, appearing on behalf of Dominion Energy South Carolina. It's a pleasure to appear before you today, and we appreciate the opportunity that you provided to us to weigh in on this issue. I thought I was standing far enough away from the fight to not get pulled into it, but apparently I was standing too close. So here I am. The issue presented by ORS appears on its face to be straightforward, and that is, does Section 5841 20E2 or Order 2024-141 require the Commission to approve the administration, implementation, or results of each future procurement of renewable energy and capacity resources, or find that its procurement is in the public interest? Now, ORS has presented you with a very tight issue, with the focus being on Section 5841 20E2 and Order number 2024-141 as being the controlling legal authority to answer this question. And ORS has concluded that an electrical utility may only obtain approval of its procurement of a renewable energy resource by way of a company's commission-approved CPRE program as part of the traditional rate-making process. In other words, what ORS is saying to you is, utility, you have a CPRE program, go administer it, go implement it, and procure whatever's best for you and your customers. But until you file a rate case, the commission is unable to render a decision regarding the actions that you may have taken in furtherance of your CPRE program. And while the company appreciates ORS's argument on that point, that is an incredibly risky course of action for the utility, because there may be times when a utility would like to know from its regulators whether it's on the right path. And we do not think it is unreasonable or contrary to South Carolina law to make such a request and have the commission make a ruling, and I'm going to explain why. The regulation of electric utilities is a complex endeavor, as you well know, and because of the complexities, you cannot, in this instance, look at a single statute or commission order to arrive at the correct answer. Instead, the commission must take a step back and look at the big picture. And to do that, I think you've got to reframe the issue. And the issue is better stated as, may a utility request the commission to approve the administration, implementation, or results of any future procurement of renewable energy and capacity resources, or declare its procurement in the public interest? And the answer to that question is yes. As long as the commission has the statutory jurisdiction over the matter, then a utility may present its request to the commission, and the commission has a duty to make a ruling. ORS is arguing that you don't have jurisdiction to decide the matter until a rate case is filed. ORS's argument is really a function of timing. That is, when should the commission take the matter up? And clearly ORS believes that even though the utility is acting in furtherance of a commission-approved CPRE program, the utility must wait until a rate case to learn the ultimate fate of its actions. And I say fate here, and when I say fate here, I'm talking about whether its actions were reasonable and prudent. Under South Carolina law, the commission supervises and regulates the rates of electric utilities. It is undisputable that the commission has broad authority over electric utilities. You can also look at section 5841-20E2, which makes clear that the commission has the authority to determine whether a CPRE program is in the public interest. And when you declare something to be in the public interest, which is what you've done for both Duke and Dominion Energy South Carolina, I don't think your authority over that matter is suspended or otherwise held in abeyance until a rate case, which is what ORS is asking you to conclude. So again, the question before you is one of timing. That is, when does the commission exercise its authority? And this matters because this is the point that ORS wants to get at in this generic proceeding. And like I've said earlier, ORS is effectively saying to the utilities, you've got to, even though you have a commission-approved CPRE program, you cannot ask the commission to approve anything related to or done in furtherance of that program until you complete your act and then seek recovery of the cost in a future rate case. And I want to pause here and explain a couple of things when it comes to cost recovery. When you're thinking about cost recovery, you're analyzing a lot of different things, but for today's argument, it's really two things. It's the action that led to the cost, and it's the cost itself. These two concepts are very important, action and cost. To obtain cost recovery, a utility must demonstrate that its action was reasonable and prudent, and it also must demonstrate that the cost itself was reasonable and prudent. In this instance, action is when the utility does something in furtherance of its CPRE program, and cost is the expense incurred as a result of that action. So the action generates the cost. Now, respectfully, ORS is applying the traditional rate-making approach unfairly toward utilities in this instance, and whether intentional or not, it presents a future scenario of where the utility could find itself in an unfortunate position. That is, a ruling finding that the utility's actions were not reasonable and prudent, and therefore the cost will be disallowed. And that is what Duke Energy appears to be trying to avoid here. And I don't fault them for that. In fact, I think that is a wise decision. Before you tear down the road of signing contracts, ordering solar panels and batteries, constructing and operating a renewable energy facility, let's do a check-in with the regulator who approved the CPRE program. And as I stated earlier, when you think of a cost recovery proceeding, you can automatically gravitate toward the cost itself and focus on whether the cost is reasonable and prudent. But before you get to the cost, you got to take a look at the action that led to the cost. And that can be done by viewing the action and cost together in the same proceeding, which is what ORS is advocating. And under that argument, however, there is significant risk for the utility. And alternatively, you can look at the action now, not the cost, and determine whether the utility is on the right path. And as I understand it, Duke Energy has done some action in furtherance of its commission-approved CPRE. And Duke Energy is asking you to decide whether its action was done in compliance with the law before they go any further on the matter. Again, that's not an unreasonable request over which you have jurisdiction now to decide. And I'm not aware of any South Carolina law that prohibits a utility from making such a request. Duke Energy has cited to you, among other things, the regulation that allows the utility to file an application. Regulation 103-823 is clear that as long as the commission has the statutory authority to rule on the application, then the application is appropriate for disposition. At this point, you might be asking yourself, why would a utility make such a request? You've got the approval, just go do it. To that, and to answer that question, I've got to pull back the curtain a little bit and let you know what it's like to work at a utility. I want to emphasize here, utilities routinely get to that point in the road where they need to make a decision. Do we keep going? Do we hit the pause button and reassess things? Or do we just stop the matter altogether? And as part of that calculus, one item that the utility will analyze is the cost of the project. It's one thing to spend a little bit of money on a matter and not know whether your action was done in furtherance of the matter that may be appropriate. It's quite, and that may be a risk that the utility is willing to accept. And it's quite a different matter, however, when you're about to spend millions of dollars on a matter and not know whether your actions have been appropriate. That's the risk that the utility would like to try to mitigate. There are real people working at the utility who are making these decisions. This is real life, and if you don't get it right, there will be real consequences. And for the utility, this boils down to risk. How much risk are we going to require that the utility accept? ORS's actions in this docket are signaling that it wants the utility to take all the risk related to its CPRE program. And like I said earlier, it's not unreasonable for a utility to make a request in an attempt to mitigate risk. Before it spends possibly hundreds of millions of dollars on a project, the utility would like to know sooner rather than later whether we're all working on the same page and if it's okay to move forward. And at its core, that is effective and efficient regulation. In fact, there is one statute that directly addresses this point, and it's South Carolina Code Section 5841-05. And under that statute, the General Assembly provides this commission with specific directions when it comes to addressing matters related to renewable energy. And I say directions because that's the title of the statute, Direction to Commission. And here's what the General Assembly has told you. The commission is directed to address all renewable energy issues in a fair and balanced manner. The commission is directed to address all renewable energy issues in a fair and balanced manner, considering the costs and benefits to all customers of all programs and tariffs that relate to renewable energy and energy savings, both as part of the utilities power system and as direct investments by customers for their own energy needs and renewable goals. The statute, to me, is crystal clear that the commission must address all renewable energy issues in a fair and balanced manner. And I would submit to you that it is fair and balanced to address the actions, not the cost, now, rather than to wait for this one item to be rolled up in the casserole of a rate case. And here's what I want to leave you with. A utility has the discretion to file an application regarding any matter for which the commission has authority over and can request a ruling. Your regulations allow that. Once the commission has exercised its statutory authority and found a CPRE to be in the public interest, your statutory authority over that matter is not suspended or otherwise held in abeyance until the utility files a rate case. Upon a utility's request, you may therefore evaluate a utility's actions now related to activities performed in furtherance of the commission-approved CPRE program. And third, your ruling on the matter as presented does not in and of itself lead to automatic approval of cost recovery. Cost recovery is another matter for another day and another docket. Thank you, Mr. Chairman. This concludes Dominion Energy's position on this matter, and I'm happy to answer any questions that you may have.
Thank you, Mr. Burgess. Any commissioner questions? Commissioner Williams?
Thank you, Chair Powers. Thank you for being here, Mr. Burgess, and your presentation and your simple focus on action and cost. I want to think some more about action with you, and in the case of an IRP, we have clear statutory reference to the fact that we are making a determination at this time. So would you, with that in mind, would you consider our approval of an action as absolute and forever? Or are there other factors that we might look at between a CPRE approval and cost recovery related to that action?
Sure.
You know, the companies have the discretion to implement the action prudently, some of which is not wholly related to cost. Would you agree with the premise of the question, and does that make sense?
I'm trying to follow exactly what you're asking, so I'll give you what I think you're asking, and you tell me if I've missed the mark or not, and
Sounds good.
We'll retry again. So the answer to, I think I heard you say, does a commission's decision regarding the action constitute its final authority on that matter, and is it forever etched in stone? And I think the answer to that question is no. And there's a couple reasons for that. Number one, if you, and I know you have, read ORS's testimony in many, many dockets, ORS is very clear. If we learn of something that we didn't know today, we reserve our right to change our mind in the future. I think that equally applies to this commission as well. Your decision is only as good as the facts that have been presented to you at the hearing. So I do not necessarily think that once you get, or once you make a decision, that then and therefore closes the matter forever, and you can never question the utility's action. I think you certainly can do that. But the bigger thing here is what your decision means to people who work back at the office. There are folks, not standing up here today, who make decisions based upon what you do. There are people who don't even work for the utility, who park money with the utility, who make decisions based upon what you do. So it is while it's not final, it is a good signal, and I think Mr. Wellborn indicated that earlier. It is a good signal to the commission, or excuse me, to the company, that, well, it's better to know a little bit than not know at all as to what the mindset is of the regulator before we, like I said earlier, tear down the road and start spending significant sums of money without having some sort of indication that we're doing it correctly. And more importantly for this proceeding, this is a function of where the commission has found a CPRE program to be in the public interest. And I think what Duke is saying, and what I'm saying here too as well, is that we don't think it would be wise for this commission to say, here's your approval, and we'll hear from you whenever you get done. Come back and chat with us. That's really risky. And I'll say from Dominion Energy standpoint, it might be even a little more risky because Dominion Energy advocated that a CPRE was not in the public interest, and this commission disagreed with us. We obviously accept that decision. So whenever you tell us, no, you will go do something, well, whether you like it or not, you're the regulator, and the utility's got to go do it. And we obviously have a separate docket to deal with the CPRP program that we developed in accordance with the instructions that you provided to the company. So I know that's a long-winded answer, and I hope somewhere in there that kind of got to the point that you were asking about.
Excellent. You listened well, and you helped to better define the steps within the approval of the action, and that it's not final and that you also talked about legal provisions that relate to the commission and others making decisions based on the information we have at the time. So I thank you for that. I'm going to ask you another question, because in looking at 20E2, it strikes me that this is most relevant to the starting of the CPRE programs within the state. From where you sit, is this about more than that? Is this about the ongoing relevance of CPRE, or was this statute related to the initial creation of CPRE programs?
Sure. Act 62 is a lengthy act, and there's one sentence, one very long run-on sentence that's embedded in Act 62 that speaks to a CPRE. And I think if you read it without lifting your head up and kind of looking at the entire landscape, I think somebody could easily conclude that, commission, you had one job and one job only, and congratulations, you did it. And that was to open a generic proceeding and make a determination on whether or not a CPRE is in the public interest. You've done that. Let's wash our hands, and we'll see you when you file your rate case. I don't think that is an appropriate or the correct interpretation of the statute. And I kind of alluded to that earlier. Again, going back to Dominion, we argued, and I sound like I'm crying over spilt milk here, but I promise you I'm not. We argued that a CPRE wasn't necessary. You disagreed. When your regulator tells you you will go do something, I don't think it would then be appropriate for the regulator to take a step back and say, good luck, come back in a rate case. I do think that should be left to the discretion of the utility. The utility may feel very comfortable about moving down a path of engaging in a CPRE, executing on an RFP, signing documents, building things, and come to you and say, hey, here it is in a rate case. How do we do? However, like I said earlier, it's usually that dollar threshold that, at least in my experience, is what gets people's attention. And when you're spending significant sums of money in furtherance of what the commission has instructed you to go do, I don't think it's unreasonable, and in fact, I think it's very wise, that you would come back to the commission and just say, hey, this is what we've been up to, not asking you to approve any cost recovery. We totally get that. I've heard the arguments from ORS about having other people come in for a rate case and let them speak their mind. But because you authorize us to do this, we do think it's appropriate to do a check-in with you and let us know how we're doing. Again, not saying to you that we're now going to fly this order from the flagpole and use it as a sword, but it helps management make decisions. And that's what's important. Otherwise, they're just sitting there, and I'll tell you just from experience, management will look at you and say, are we going to get cost recovery this? I don't know. I don't know if we are or not. The commission told us to get out of here, come back in a rate case. Okay, well, we need to think about this a little bit further. So hopefully that helps you make your decision. And really that's our role here, quite frankly, is to help you make your decision. Because again, Dominion Energy is in a little bit of a different boat than what Duke Energy is on this.
Thank you. And that's exactly why I asked you the question, just to hear your answers from your perspective. No further questions. Thanks again.
Thank you, Commissioner Williams. Commissioner Vice Chair Williams.
Thank you, Mr. Chair. The lethal blast radius of a mortar is 30 meters. So you are definitely way too close to survive. In all seriousness, I appreciate your presentation and everyone's presentation up to this point. My question is whether or not you agree that what we're discussing here in terms of, you can describe it a lot of different ways. Let's just say a check-in. Is it not some level, even if it's also very small level of deviation from the traditional process in South Carolina?
Well, it may appear to be that way, but I don't think it is, given the fact that the General Assembly instructed this commission to open the generic proceeding and make a determination of whether or not a CPRE is in the public interest. You've done that. It's a little different in the sense that if a utility were just going through the normal course of business and there was no statute that instructed the commission to do something that caused the utility to appear before it. So, for example, if the utility is wanting to build, let's just say its own, I'll just make up a number, 50 megawatt solar farm. Clearly, that doesn't trigger the requirements of the Siting Act. There's no requirement that the utility come before you to ask for any blessing on that. I probably would tell the utility it's a little odd if you want to go ask for that approval, and I'm not sure the commission is going to give it to you because I don't think they would be required to do that in that situation. Following that to its end, the utility makes a decision to build a 50 megawatt solar farm, and then they would follow the traditional rate making process of bringing that to the commission in a rate case. Let's make a decision or determination whether or not the action to build it was reasonable prudent, whether the cost to build it was reasonable prudent. This is a little different because you have a statute specifically directing this commission to do an action. You have then taken your duty and have acted upon it by instructing utilities to stand up a CPRE program. And then secondly, like I touched on toward the end of my argument, you have a statute that gives you clear direction that you must make a determination with respect to all renewable energy issues in Act 62 in a fair and balanced manner. And I do think that if you went down the traditional rate-making approach, which is what ORS is advocating, I don't think that's fair and balanced because you're asking the utility to step out on a limb and do things in furtherance of what this commission has instructed them to go do without any inclination as to whether or not it's the right thing to do. So, and again, it goes back to what I said earlier. I do think this commission, I think everybody in this room wants effective and efficient regulation. And when you have an order that's been issued to you to go do something, I do think it is prudent for the utility to come back, if it wants to do a check-in with the commission to make sure that it is following the guidelines of the commission appropriately.
Thank you for your answer. You talked a little bit about risk to the company. Are you able to be agile and flexible enough to consider what, if any, risk are out there for the commission or for the Office of Regulatory Staff or even for ratepayers?
So, number one, the risk that the biggest risk on the table is obviously what I've identified earlier, and that would be what I'll call the worst case scenario. And the worst case scenario is that the companies execute on the CPRE, they issue RFPs, and they build or have someone else build or enter into PPAs to add generation to its portfolio, and this commission says, nah, you're not getting recovery of any of that. That's a bad day at the utility, and it's probably the day I pack up my briefcase and you never see me again. So that's a rough one. That's a rough one. As it relates to risk for ORS and this commission, you can only mitigate risk. You can't eliminate the risk. And maybe the risk for the commission or the risk for ORS is you have someone be critical of you in the paper or be critical of you if you're being reviewed by your bosses and what have you. I mean, that's obviously a risk. As it relates to customers, the risk would be that the company has spent money that maybe it didn't otherwise need to spend or shouldn't have spent, and we can avoid that situation altogether. At the end of the day, I think it was Commissioner Caston mentioned kumbaya, and I don't know that you can truly get kumbaya in a commission setting with all the different interests and parties that you have here, but you try. We've done that in rate cases, as y'all have seen here recently this past summer. But at the end of the day, I do think it's about trying to mitigate risk for everybody, and everybody has an interest in the matter. You have an interest. ORS clearly has an interest. They're doing their job representing the public interest. You're doing your job representing the public interest or deciding the matters that impact the public interest. And the utilities are doing their job as it relates to making sure that they protect the interests that they've been charged with carrying out. So I don't know what specific risk you eliminate at the end of the day, but I do think at least everybody marches forward together, and that's what we need to do as it relates to this matter and obviously other matters that are facing the utility industry today.
And thank you again for your response. And I believe this would be my last question. It sounds like what I'm hearing from you all thus far is just because we haven't regulated this way in the past doesn't mean that it's illegal or imprudent to consider regulating this way moving forward.
That's exactly right. I think your regulations, when you look at the CPRE statute and you look at your regulations, I think the law is clear that the utility has the right, the discretion to come before you and ask for relief, whatever form of relief that is, as long as you have statutory authority over the matter. That's the linchpin. And I do believe you have statutory authority over a CPRE program. I don't think your statutory authority ended the day you issued your order, and that we now have to wait until rate case to decide issues related to a CPRE. Your regulations are pretty clear. And in fact, as it relates to Duke Energy, when I reviewed the documents in this case, there was an attempt made to cease this proceeding from going forward, and the commission thought otherwise. You issued pre-filing testimony deadlines, you set the matter for hearing, and those parties kept kind of going down the road till we get where we are here now. But I do think that it is appropriate for you to hear the issue. Now, that doesn't mean, and I'll be the first to admit this, that doesn't mean you have to agree with the applicant. You could certainly say, hey, we don't think you're on the right path. We think you need to do something different. Under your regulations, you have to issue an order putting some finality on the request. But at the end of the day, I mean, it's up to you to decide whether or not they should be granted the relief that they've requested in their application. And it's up to the applicant to put forth that case in order to get you to do what they would like you to do. And obviously, it's up to ORS and other parties to argue their case in hopes that you won't do what the utility has asked you to do, assuming that they take the opposite side of the issue.
Thank you, sir. Mr. Chair, that's all I have.
Thank you, Vice Chair. Commissioner Caston.
Thank you. Still morning, Mr. Burgess.
Good morning.
I guess relative to the presumption that the utility in a rate case, the rates are assumed correct, expenses assumed correct, and that those opposed must prove otherwise. Is that correct?
So when a utility files for a rate case, you are correct. The expenses that the company presents to the commission, there is a rebuttable presumption. And that's important. There's a rebuttable presumption that those rates are and those costs are indeed reasonable and prudent. It's up to ORS and other parties to raise the issue that the expense may not be reasonable and prudent. And then that's where the fight, if you will, happens, so to speak.
Fight or disagreement?
You can't see the bruises on my body, I'll tell you.
I understand. And the acronym, CPRE, you remember what? Competitive procurement, right?
Yes, sir, that's correct.
And what I think I've heard from you with the questions and the responses you've given is that, and it's amazing, one sentence legislation can cause this much discussion. But Dominion's position is this one sentence on competitive procurement, allowing the process to be open and transparent. If you're going to have renewable resources, is that pretty much the gist of the CPRE?
That's exactly right. It's a competitive procurement of renewable energy resources. It's not an all sources solicitation, which would be different. That's where you would have gas or maybe coal or something else bid into the process. This is just for renewable energy resources like solar, batteries, what have you.
Correct. I understand. Thank you. And as I understand it, if the utility determines, in their opinion, in their view, that they believe they need X amount of this renewable source or X amount of that, then you just got to, however you acquire it, just needs to be open and transparent process. Is that correct?
Well, let me just add a little bit of that. So
Okay.
the need, it's the need is borne out through resource planning, through the IRP. So that's what the utility would rely upon as far as identifying the need. And then to the extent that the need turns out to be some type of generating source, and the utility decides, hey, we think that the most cost-effective generating source to solve for the need happens to be a renewable energy resource, then yes, the company would issue, pursuant to a CPRE, would issue an RFP out to potential bidders, and that process would be open, non-discriminatory. We've outlined that in our filing. You're gonna see me on December 5th talking more about this and the program as it relates to Dominion Energy South Carolina. But that would be the program that it would execute in furtherance of satisfying the need that was identified through the resource planning process.
So we've mentioned CPRE, IRP, and rate. Covered some big ones. In the discussion on risk, why? And I guess this is along the lines of what Commissioner Jay Williams was asking or trying to get clarified, is why would the utility need more than they already have under current laws? I mean, I've heard what you said, and I'm trying to distinguish why is this different? I mean, it sounds like a pre-approval. Is that what I'm hearing?
I don't think it is a pre-approval in the sense that once you issue your order, then this matter is over, resolved, it is settled, and we're not litigating that anymore. I don't think that's what Duke is saying to you, and if I'm wrong about that, I'll let Mr. Welborn correct me. But if I'm hearing you right, it sounds like to me you're thinking that because you have a rebuttable presumption, then you should carry on smartly and worry about these matters when a rate case comes. And while I appreciate that, the presumption is rebuttable. And it's not, and we've talked about this earlier, at least Mr. Welborn did, that through Commissioner Belder's question, is it's not a guarantee. It's not a guarantee. And I think of this really more of maybe like a speedometer. We're kind of sitting at 0, and 0 being we don't know whether we're following the process correctly or not. We're not sure. We think we know. We think we know, but you don't know until the decision maker tells you yay or nay. So, okay, well, how do we move from that position to get a little more comfort that everything's going to be okay at the end of the day? And the only way you do is you have to move that needle. And let's assume like 100. I'll just say 100. It would be like full blown certainty. We know we're not going to get to 100, but the closer we get to 100, the better we sleep at night at the end of the day. And I think what the utilities are saying to you is that we'd like the opportunity, and we think we have that right under existing law today, to make the request of you, hey, are we doing what you ordered us to do correctly? And it would be good to know that sooner rather than later.
All right, well, you talked about the order, I guess whatever the expectations are in an order, and I'm kind of trying to understand that.
Sure.
Because, we've talked about the program, the bones, and all this stuff. And while I've not heard you say this specifically, I don't want to read any more into what you said than I should. But the expectations in this order, whatever proposed order you would suggest, is the company expecting the commission to say, yes, we think you need X percent of this renewable resource or this. Yeah, we're going to agree to whatever it is that you've proposed. Are you asking for that, something similar to that? Or?
No, sir. I do not envision a utility, and I'll speak for DESC, I do not envision DESC coming to you saying that we are asking you for an order to bless this exact generating resource that we want to go build. It is, for purposes of this generic proceeding, ORS is telling the utilities, we can't even ask you. That's what they're saying. We can't even ask you. And what I'm telling you today is, yes, we can. We can ask you as long as you've got the statutory authority over a matter, and I think you do have the statutory authority over a competitive procurement of renewable energy because you've ordered us to go do that. We can ask you. That's simply the issue that's before you right now as it relates to DESC and even Duke to a certain degree, is whether or not that authority exists. If you agree with ORS that you don't have that ability to do that and you have to wait till a rate case, then I think you're going to see utilities look at things a little bit differently than maybe the way they're looking at them right now.
Okay, I'll thank you. Mr. Burgess, no more questions.
Good morning,
Commissioner Belson.
Thank you, Mr. Chairman. Good morning, Mr. Burgess.
Good morning.
Following up on what Commissioner Caston was just talking about, and let's just kind of think of a hypothetical situation. The Commission's issued an order where it's approved the framework. I'm going to call it the framework at this point. Really all the Commission could do in an order on an application like this is basically say that, yes, you followed the framework that's set out in the order. Is that correct?
I think that's accurate, Commissioner Belzer, yes.
Does it matter, just kind of thinking ahead a little bit here, does it matter whether the entity seeking approval of a program has its rates set by this commission or not? I mean, would an entity that doesn't have its rates set by this commission need to come back and seek individual program approval?
That may be a question better answered by
I understand.
my colleague here.
It's just what made me think about it.
But I will say, I think the answer to that question depends upon what the commission puts in its order. So, for example, and I haven't. The only thing I've read related.
Well, that's just something that popped in my mind this morning as we were kind of going listening to y'all.
I think that's a fair point because as I was preparing for today's argument, that popped into my head as well, and I did take a look at Santee Cooper's position statement, and while I have not read the order that this commission issued related to that, it did appear to me that there were some subsequent actions related to the CPRE that the commission instructed Santee Cooper to do.
Well, and I'll just say, I mean, this is for the edification of the room, really. This motion, the responses, and the arguments this morning have made me realize that perhaps I can't speak for the entire commission, needed to probably have a better use of terms. Because I think we're talking about, we're using CPRE to refer not only to the framework of what needs to go into the, as far as the issuance of the RFP and an independent administrator and report and all that. I think we're using CPRE to cover that, as well as using CPRE to cover the discrete different programs that might be issued under that. And I'm not so sure that we don't need two separate terms or somehow differentiate to avoid some of the confusion that I'm experiencing. So I just have to put that out there. So for lack of a better term, I'm talking about the framework, and then I'm talking about a program. But
Sure.
But that's just an observation. So thank you for your participation this morning. Appreciate
Thank you. You're welcome.
your thoughts.
Thank you, Commissioner Wilson. Commissioner Thomas.
Thank you, sir. So I know this is about renewable energy, CPRE, but just to kind of get a little bit bigger overview, I guess, in my mind, if we are talking about traditional generation sources, in your opinion, is there anything in South Carolina law that gives assurance, and that's a stronger word than I'm really want to use, in terms of future recovery of a traditional asset, just for comparison purposes? Is there a difference?
Sure. There is, I don't think you're going to find anything in South Carolina law that gives the utility any assurance that a traditional generating source, if you will, is going to be given cost recovery approval. And I'll give you an example. And I think this is probably a good example. Under the Siting Act, we have, if the utility is going to build a generating resource greater than 75 megawatts, it has to come to this commission to ask for approval to do that. That's bite one at the apple. Come to this commission to ask for approval of that. And then you issue, hopefully, if the utility's done their job, you would issue a certificate of public convenience and necessity. That is the document that the company relies upon to go build the generating facility. That's not going to stop somebody in a rate case from arguing you should never have built it to start with. That's not going to stop them. However, the utility can hold that up as a shield and say, hey, appreciate your argument, but we did get approval under the statute to do this. And then really it becomes, when I mentioned earlier, action cost. I think in the example I just gave, you're really focusing on the cost of what that actual asset ended up costing you. Did you do things that were imprudent that caused the cost to be more than maybe what it should have otherwise been? That's typically the review and audit and investigation, if you will, of that particular matter in a rate case.
And keep hearing about this feedback. You know, it'd be good for the company to get feedback during the process. Could some sort of feedback be a part of an annual IRP update?
I think that you're testing my knowledge of the IRP statute, but I think there is a provision in the IRP statute that's pretty open-ended, and it says you'll put all these things in your IRP, and then anything else the commission, I'm paraphrasing, mind you, anything else the commission thinks you should put in there. So the answer to your question is yes, I do think that if this commission wrote into an order disposing of an IRP, it could include a provision such as that to require the utility to keep the commission updated and making that part of an IRP proceeding going forward. I will tell you, however, in IRP, you know this, but I'll state it for purposes of the record, the IRP is, for lack of a better word, litigated once every 3 years. We have IRP updates along the way, and those IRP updates typically do not result in some type of hearing before the commission.
All right, thank you. I appreciate that.
Any further questions? Thank you, Mr. Burgess. We're going to take a break now. 12, we'll be back here at least by 12:15. I may have a couple of questions, but if I do, I'll try and make them yes or no questions.
Okay, and I'll be certain not to talk to our lawyers during the break.
Please don't.
I'm just kidding.
Thank you. We're in recess. Welcome back. We are back in the docket 2024-270E as to the consideration, evaluation of competitive procurement of renewable energy program solicitation pursuant to Commission Directive Order Number 2024-647. We were in the questioning part for commissioners. Mr. Burgess, you are here on behalf of Dominion, and I will try and make it a yes or no question. As far as if you say we would still have authority under a CPR order to open it, it would take some action on the part of either the company or ORS or someone to do it. We would not, of course, be able to just reopen unless there was some sort of application or something brought before us. Is that correct?
That's the typical way it works. Yes, sir. The utility would make a request of the commission.
And I know being a storm state, CPREs, I thought a lot of it seems to be or has been available or may be available for storm damage, that sort of thing. But when you talk about risk with a CPRE, the lower the risk, the better the outcome the company's going to get, the better the interest rate, the better the bonds or whatever. So the better the risk, the better all the way around. Is that correct?
Yes, sir. I do believe that's a fair statement. I don't know all the financial details behind what goes into as far as raising the money to build projects like this, but just generically speaking, the lower the risk, the better for everybody. I agree with that.
The better the credit rating the company would have.
I would agree with that, absolutely.
Okay. Well, thank you very much. That's all I have. Anything else? That's it. Thank you very much.
Thank you, Mr. Chairman.
All right, we're going to keep going around the room. Santee Cooper.
Good afternoon, Mr. Chairman and members of the Commission. For the record, I'm Megan Driggers on behalf of Santee Cooper. Deputy General Counsel for Regulatory Compliance, Steve Pelcher, is joining us virtually, but I'm offering our position statement today. The issue presented in this matter is whether or not the Commission approval is required for each future procurement of renewable energy. By way of background, ORS filed a motion for declaratory judgment and motion to strike in docket 2024-144E, a docket in which Santee Cooper was not a party. That was the genesis for this docket. In its motion, ORS requested the Commission open a generic docket for interested stakeholders and utilities to discuss CPRE generally and to discuss whether or not Commission approval is required for each future procurement of renewable energy. Thereafter, the Commission Directive, styled Order Number 2024-647, opened this generic docket. There was a directive served upon Santee Cooper along with a motion for declaratory judgment from ORS, and I consider it less of a blast radius and more of an invitation to the soiree. So we're here to discuss the portion of that motion for declaratory judgment related to RFPs and whether or not Commission approval is required. And as we discussed, as other parties have discussed, Santee Cooper stands out. We're the state's public utility. Our CPRE program came about as a requirement under Act 90. It's codified at South Carolina Code Annotated, Section 5831-227, unlike Act 62, which the other utilities' CPRE programs come under. In compliance with that statute, Santee Cooper filed its proposed guidelines for Commission approval in November of 2022 in docket 2022-351E. There was an evidentiary hearing held in the matter with interested stakeholders participating, Santee Cooper participating, and the Commission's independent consultant offering their analysis. On January 3rd, 2024, the Commission issued its order approving Santee Cooper's CPRE program guidelines. That, we consider that approval, along with the solicitation, the approved program. So to us, those approved guidelines and a tranche of renewables, that solicitation, those together are an approved program. So within that order and within the statute, there are enumerated requirements for each RFP under the CPRE program. Those requirements dictate what needs to be done before, during, and after an RFP is issued by Santee Cooper for renewable energy under these CPRE program guidelines. Santee Cooper's first solar RFP under the approved CPRE program was issued June 10th, 2024, and that was administered by TEA Inc., and the bids were due July 22nd, 2024, and are being evaluated by Santee Cooper, our third-party consultant, and Central Electric Cooperative. So our position today is essentially a restatement of the position letter that I filed September 30th, 2024. It's Santee Cooper's position that approval of each RFP solicitation is not necessary. It would be redundant of work done by not only the commission, but interested stakeholders and utilities in the CPRE process. It would counter judicial efficiency and economy, clog the commission's busy docket, and delay issuance of these RFPs, and delay the process for utilities that need these resources, and also the developers that intend to bid and may be awarded solicitations. Those approved guidelines are a lodestar for the RFPs that we issue under this program. So like I said, those guidelines and the solicitation are the approved program. There's no need for an additional imprimatur for each of those. And I don't want it to seem as if we're suggesting that once the commission approved our CPRE guidelines and our CPRE program generally, the commission's job is done. There's a significant number of checks and balances and oversight. As I said, we have to file with the commission informational notices, the 45-day notice, the 90-day notice. We send quarterly updates once a solicitation is issued. Once a bid's received and selected and that process begins, we're required to submit to the commission a report, a public report, which summarizes the entire process and the award. And to require approval and for that to become approval of each RFP to become de rigueur or the requirement would create inefficiencies, not just before the commission, but for renewable energy programs generally at the utility and for developers. And so thank you so much for the time and opportunity to present our position today.
Thank you, Ms. Driggers. Any questions from the commission? Hearing none, thank you very much.
Thank you.
All right. Carolina Clean Energy Business Association. Mr. Witt, Mr. Burns. Take your time.
How's that? There we go. Thank you. Mr. Chairman, Mr. Vice Chairman, members of the commission, my name is John Burns. I represent the Carolinas Clean Energy Business Association together here with Mr. Witt today. The parties that are actually involved in the motion before you have really briefed this issue extensively and very well on both sides. We didn't intend to add to that briefing and add to the pile of paper that you've had to go through on this issue. But it is important to see SEBA to interject in the argument and establish the stakes of this discussion and why it is important to our members who are renewable energy developers, renewable energy customers, and service providers, why it is important to them that we get this decision correct. And there's three main points to that. First, and calling back to some questions I recall from the IRP proceeding that we all just finished, is what has changed in the market, in the industry to lead us to this point? Why are the parties arrayed as they are? What is requiring action on CPRE and IRP now? And what does it mean? And why is it any different than it was 2 or 3 years ago? The answer to that is that in a very short period of time, as you are all aware, We've gone from a relatively static energy environment where a very small number of older technologies provided energy to a fairly static and predictable load. And we've gone to a fast-changing environment, a dynamic environment where all utilities all across the country are retiring significant amounts of coal generation. And we are faced with precipitous load growth at the same time. And from lots of different types of customers who have varying needs and preferences for the source and type of the power that they get. On top of that, we have a pretty close parity among several new resources, including gas, solar, storage, hydro, and potentially wind and new nuclear, all of which will be used to replace that old static mix. That makes this commission's determination on questions such as those before you today hyper-relevant in a way that it may not have been even 2 or 3 years ago. This commission has a responsibility to be involved in that transition and to set out guideposts and what is in the public interest, and even separate from that's even separate from your important rate-making responsibilities. Second, this commission has the authority to act, as my colleagues over there for Duke have talked about. It's found in 2 clear statutes. The first is 58.3.140A, that gives the commission its express power and jurisdiction, quote, to supervise and regulate the rates and service of every public utility in the state, and to fix just and reasonable standards, classifications, regulations, practices, and measurements of service to be furnished, imposed, or observed and followed by every public utility in the state. Notably, that power and jurisdiction is not limited solely to a periodic review of the utility's rate structures. Rather, the General Assembly gave broad authority and jurisdiction to supervise, regulate, and fix standards and practices that every public utility shall observe those and follow those regulations and decisions. It would be a rather toothless authority if that was limited solely to a biannual rate case. As it seems to me, at least, it seems to us as ORS is arguing in this motion. The second section is Act 62, codified at 58-41-20E2, which we've discussed at length this morning. But that section specifically authorizes the creation of programs for the competitive procurement of energy and capacity from renewable energy facilities. Thus, this commission's power regarding CPRE in particular extends not only to the creation of generic programs, but also to the actual procurement of the renewable energy resources themselves. So CCBA agrees with Duke that this commission may make public interest determinations regarding CPRE programs and any number of other issues outside the scope of an actual rate case. But CCBA also submits that this commission can also direct any public utility in this state to commence and follow through on a program to procure the resources consistent with an IRP. Alternatively, you could wait and deny cost recovery for more expensive resources if renewable resources are not procured through a viable CPRE program. This commission has the authority and the call to act in these circumstances, to not only approve the format of a CPRE program, but to supervise and oversee, indeed to require the procurement of the necessary volumes of these resources consistent with an IRP. As discussed at length in the recent Duke IRP hearing, an IRP means something. It has to. Or the time and effort expended by the utility, interveners, and this commission would be wasted. To meet the dynamic energy need I discussed earlier, this commission must be able to approve and direct certain activities and programs and to enforce those determinations. And similarly, a CPRE proceeding should also mean something. Now, the third issue is that contrary to ORS's argument, this authority does not mean the abandonment of this commission's other key responsibility in utility regulation, which is rate making. Authorizing actions as being in the public interest and consistent with statute does not mean that the cost recovery determination is pre-decided, and I do not understand Duke to be asking you to do that. I think there's 2 examples that might help, and one of them was alluded to earlier by Mr. Burgess. If this commission undertakes a Siting Act review of a potential gas plant, for instance, the utility must come before you and show the need and meet a number of other requirements under the Siting Act for the placement and operation of that gas plant. This commission would then consider that and all arguments to the contrary and issue a certificate of need if it finds it appropriate. Years later, after bidding, construction, interconnection, and commencement of operation, that utility would come before you for cost recovery for the construction of the plant. The issuance of the certificate of need would certainly be relevant to that determination, but it would not be determinative of that determination. If the utility poorly managed its EPC process, for instance, and that gas plant came in 50% over cost, the commission would not be bound to approve recovery of that additional 50% at all. By the same token, if the utility came in on time and under budget, the statement of need would likely be very persuasive to you in the determination of the recovery of those costs. But you would not have predetermined that issue ahead of time in the certificate of need process. And just as a hypothetical, if the commission decided to open a docket in response to Hurricane Helene and held hearings and proceedings concerning reliability and resilience of the grid and ways utilities could make it more resilient, determinations in that docket that it would be a good idea to engage in certain grid hardening approaches or security or vegetation management serve as guidance for that utility in its decision-making processes and its actions. It knows that this commission has already weighed in. It can act with at least some understanding that the actions will be seen as necessary, but the commission did not forfeit its obligation or ORS's ability to object or any other intervener's ability to participate in the later cost proceeding as to whether those actions should be recoverable. So CCBA submits that CPRE programs are similar to those concepts. In the face of a rapidly changing energy market and the need to obtain resources competitively and at least cost for the ratepayer, utilities need to be able to plan, and frankly, so do developers. They need to know that this commission has reviewed and found consistent with the public interest a program to procure those resources, an amount of those resources to be procured, and sort of the details like the agreement that will be in place, the terms of that agreement. In other states, CCBA often weighs in on whether new security that's included in the terms of those deals is appropriate. We've weighed in and had arguments about that, and that's on an annual basis for each RFP. Independent power providers like our members need those assurances just as the utility does, because we want to bid on these programs and provide the power competitively for the ratepayers. As I said, we participated in CPRE programs in other states where the details of each year's RFP, its standard form PPA, and other details, including the volume of the procurement and the resources to be procured, are reviewed and approved by a regulator. Now, we do agree with Santee that that process has to not impose too much cost, red tape, and over-regulation. We think it can be done very efficiently. It is in other states. It's to the commission's advantage, it's to the ratepayers' advantage, it's to the utilities' advantage, and to third-party providers' advantage that be efficient and reduce the amount of delay as much as possible. But that can be done. None of that forecloses a cost allocation determination after the end of the procurement and the commencement of operation of our facilities. That's still within this commission's express power and authority. But if ORS's position is adopted, all of those determinations and important decisions would be waiting until a subsequent rate case. That would require the commission to abandon its statutory duty to evaluate utility plans prospectively, helping to avoid big mistakes, rather than waiting to act after avoidable mistakes have already been made. It would also severely undermine the procurements themselves, since the utility and market participants would be entering an RFP completely blind as to whether it was at all likely that the commission would find years hence that a given procurement was reasonable and in the public interest. Investors, lenders, developers would be hesitant, if not unwilling, to act on such uncertainty. And the failure of a competitive market would lead to higher costs in the long run, or worse, to lead to South Carolina failing to meet its load requirements, which nobody wants. That would hurt economic growth and the South Carolina ratepayer. Alternatively, this commission can proceed with both prospective regulation and direction and retrospective rate analysis. That's the option that we at CCBA urges you and encourages you to take. We urge this commission to reject ORS's position, protect its own power and authority to regulate, approve, and direct the form and implementation of CPRE programs and procurements, in addition to your power to approve cost recovery and rates. It's entirely within your authority, and ORS's motion should be denied. Thank you.
Thank
Happy
you,
to answer any questions.
Thank you, Mr. Burns. One thing that just hit me as one of the first part of your presentation is these companies, these businesses, don't just have needs, they have preferences. It's the type of power they want or how it's generated, whether or not it's renewable, and that's that is an increasing question or issue with companies, is it not?
Yes, sir. I think you'll find a lot of the economic development that is being conducted in Duke's territories in both North and South Carolina is driven by large users, large load customers who have a preference, indeed a requirement to the stock market that they generate that power renewably.
Which directly, we're talking about economic development here in South Carolina, are we not?
Yes, sir.
Okay, thank you. Any commissioner questions? Thank you very much.
I avoided the blast radius. Thank you. Thank you.
All right, say CCL, Ms. Mixon, do you have any remarks you'd like to make? It's your turn.
Yes, briefly, Chair Powers, for the record, I am Kate Mixon and I'm here on behalf of SACE and CCL. We concur with the arguments that have been raised by Duke Energy, Dominion, and CCEVA in opposition to ORS's motion. I won't restate their arguments here. They were all very well made, but I do want to just highlight a couple of items. First, Commissioner Caston, you asked a question and stated essentially, if a party had an issue with whether a utility CPRE was conducted fairly, that they would raise that with the commission or with ORS. And I think that is exactly why we are here. They would raise those issues in the docket reviewing the utilities procurement. And in that docket, the commission can make a decision that a procurement was a reasonable step for the companies to take and that the procurement was done in an appropriate manner. Respectfully, the commission absolutely has a significant role in what resources that the utility brings online. And in fact, that's a major part of the commission's role. The commission exists broadly to regulate the rates and services of the utilities in South Carolina. And the biggest driver of what determines a utility's rates and its service is what resources that the utilities build or acquire to meet their service obligations. And the commission has a say in about what those resources will be in numerous decisions that come in advance of a rate case or other cost recovery proceeding. So in IRPs, through the procurement statute that we're talking about today, through the Siting Act or in like facility proceedings and energy efficiency dockets, et cetera. And we see these procurement decisions as similar to those other types of proceedings that have kind of multiple stages with different types of approval. Mr. Burns and Mr. Burgess also mentioned the Siting Act, and I was also going to use that as an example. Even if the commission issues a certificate, the utility doesn't pass any costs along to ratepayers at that time. That happens later in a rate case. And the issuance of a certificate does not mean that a utility is immune from the review of those costs in a rate case. But the utility may claim that there are some arguments that should have been raised in the Siting Act docket. And so there could be limits on which arguments would be raised in that later rate case proceeding. And I made a similar point in the recent Duke IRP arguments, but one example of that would be, again, if circumstances changed and one of the actions that was approved was no longer prudent, if a utility took that action anyway, that would be reviewable in a later proceeding, and again could result in a disallowance. ORS's argument here seems to essentially be seeking to kick almost every aspect of the review of a utility's procurement process and whether the results of that is consistent with that approved process to a rate case. And we don't think that it's appropriate or consistent with the statute to prevent utilities from coming to the commission, being transparent about the procurements that they are conducting. And the purpose of the utilities filing is to keep the commission informed and provide an opportunity for the commission or other parties to raise concerns if they do have them. Thank you.
Thank you, Ms. Mixon. Any questions from the commission? Hearing none, thank you very much.
Thank you.
We are now at a point of going back to ORS.
Thank you, Mr. Chair. I promise I'll keep this brief. I know people are hungry. Mr. Chair, Vice Chair, and Commissioners, Vice Chair Williams asked Mr. Burgess a question that I believe goes to the heart of the matter here. Vice Chair Williams asked Mr. Burgess if, as a result of the CPRE statute, the Commission is now authorized to regulate in a manner that it is not previously regulated. And I may have gotten a little bit of that wrong, but I think that's the gist. And I believe Mr. Burgess answered in the affirmative. As has been mentioned, the CPRE statute is one sentence. The CPRE statute was part of Act 62. As the Commission's well aware, Act 62 enacted a number of substantive changes to the Commission's regulatory charge. Among other things, Act 62 required for the first time the Commission approve IRPs as part of a litigated proceeding at least every 3 years. Act 62 required the Commission approve each utility's avoided cost methodologies, and the General Assembly included mandatory procedural and substantive requirements related to the Commission's review of IRPs and avoided cost methodologies. There is a canon of statutory construction that says the statute must be read as a whole. The sections which are part of the same general statutory law must be construed together in each one given effect. And that was our Supreme Court in South Carolina State Ports v. Jasper County, 368, South Carolina 388. I won't belabor the point, but I think it's interesting to look at Act 62 as it relates to what you're supposed to do with avoided costs. 584120A. As soon as practicable after the effective date of this chapter, the Commission shall open a docket for the purpose of establishing each electrical utility standard offer, avoided cost methodologies, form contract power purchase agreements, commitment to sell forms, and any other terms or conditions necessary to implement this section. Within 6 months after the effective date of this chapter, and at least once every 24 months thereafter, the Commission shall approve each electrical utility standard offer, avoided cost methodologies, form contract power purchase agreements, commitment and sell forms, and any other terms of conditions necessary to implement this section. Yet, the General Assembly included no such continuing oversight language in the CPRE statute. If the General Assembly intended for the CPRE statute to change the cost of service regulatory construct in this state, surely it would have provided more direction to the Commission, to the utilities, and to ORS than is provided in the one-sentence CPRE statute. The utilities and SEBA have also argued that 583140A, the Commission's longstanding general enabling statute, grants the Commission authority to approve resources identified in a CPR RFP. Again, if the General Assembly intended to modify the cost of service regulatory construct, surely it would not have relied on the Commission's enabling legislation without more. Commissioners, these are policy issues, and policy issues must be addressed by the General Assembly. Mr. Burgess noted a distinction between actions and costs. Action is when a company does something in furtherance of a CPRE program, and cost recovery comes thereafter. He characterized the distinction as one of timing. While I'll agree there is a distinction between action and costs, in that actions precede costs, they nonetheless go hand in hand. When a utility undertakes an action under a CPRE, it is going to seek cost recovery from the Commission. As such, the difference between taking action and seeking cost recovery is really a distinction without a difference. Duke's application, in fact, makes clear that they are, one, going to acquire and construct the solar and battery resources contained in the 2023 RFP, and two, the companies will seek cost recovery for those resources from South Carolina customers in future rate cases unless the Commission in this CPRE case tells them that South Carolina does not want specific resources. Both Mr. Burns, Mr. Welborn, and Ms. Mixon mentioned the Siting Act. And this commission is aware the Siting Act applies only to generation resources constructed or sited in the state of South Carolina. As we know, Duke operates a dual state system, and recent proceedings have indicated that a substantial amount of its future generation will be sited in the state of North Carolina. As such, none of those projects will come before you in a Siting Act case. Finally, Commissioner C. Williams asked Mr. Welborn to confirm that the companies were not asking for approval of the prudency of the cost of the 2023 CPRE program. Mr. Welborn confirmed. In discussing the benefits of having an order approving certain resources, Mr. Welborn said, we can then say, quote, in a future rate case, we looked at that procurement, and that procurement's good. Here's the order that says it. That's exactly the concern of ORS. Thank you, Mr. Chair. Thank you, Mr. Vice Chair. Thank you, Commissioners.
Thank you. Any questions from commissioners? Hearing none. Is anything further from any party? I guess we're done. Thank you all for your presentation. It's been very informative and very helpful to the commission. And we're just onward and upward. Have a good day. We're adjourned.